Hello everyone, we are from Group 3 and today we will be explaining about Malaysia's contribution to the development of LOSC legal regime. Introducing myself as Sri Anjali Devi, daughter of original, and my metric number is 271718, and my other group mates are Romisha, Zahid and Islin. So let me give you all a very brief introduction about UNCLOS 3. So the UNCLOS 3 is a very prominent and successful as it has resulted in the adoption of the United Nations Convention on the Law of the Sea. So however, there were two United Nations Conference on the Law of the Sea, or we can call it UNCLOS, before UNCLOS 3. So the first or the UNCLOS 1 was held in Geneva from 24th February to 27th April of 1958, involving 86 states participated in the conference. The mandate of the conference was to examine the law of the sea, taking account not only of the legal but also of the technical, biological, economic and also political aspects of the problem, and also to embody the results of its work in one or more conventions or other appropriate instruments. So there were four conventions adopted by the conference in the UNCLOS 1, namely the Convention on the Territorial Sea and the Contiguous Zone, the Convention on the High Seas, the Convention on Fishing and Conservation of the Living Resources of the High Seas, and also the Convention on the Continental Shelf. So moving on to the second UNCLOS, or we call it UNCLOS 2, subsequent to the adoption of 1958 conventions on the law of the sea at the UNCLOS 1, and also because of its failure, the UNCLOS 2 was convened to consider the topics of breadth of the territorial sea, and also fishery limits, which had not been agreed upon. And the conference was held from 17 March to 26 April 1960. Substantive decisions on the topics of the breadth of the territory, sea, fishery limits were deferred to a later stage. And the failure of UNCLOS 1 and UNCLOS 2 led to the creation of UNCLOS 3. So the UNCLOS 3, it involved 160 states as participants, including Malaysia, and held 11 sessions between 1973 until 1982. And the General Assembly requested the Secretary General to convene the first session of the Third United Nations Conference on the Law of the Sea in 1973 to deal with organizational matters, and a second session in 1974, as well as subsequent sessions to deal with substantive work. And on 10th December 1982, the conference adopted the United Nations Conventions on the Law of the Sea, containing 320 articles and 9 annexes. And UNCLOS 3 is considered to be one of the most comprehensive legal instruments negotiated under the United Nations, as it was aimed to restructure the legal regimes of the world ocean and produce a comprehensive codified law of the sea due to the failure of UNCLOS 1 and UNCLOS 2. UNCLOS 3 is a very important element in the international system because it had covered a wide range of marine issues and provided the legal framework for a sustainable development. And if you look at Malaysia's participation in UNCLOS 3 was very prominent for its contribution in the conference. Malaysia had actively played a pivotal role in the drafting and negotiating process of the draft text of LOSC, as Malaysia was aware that UNCLOS 3 plays an integral role in the international legal system and also serves as an um, important instrument for the protection of marine environment. So Malaysia had grabbed the opportunity to defend its national interests. For instance, the protection of marine environment, navigational rights in the international straits, and navigational and fishing access in the neighboring archipelago. So UNCLOS 3 also it was held for 9 long years from 1973 until 1982, involving various states promoting and protecting their national interests in the pursuit of marine legal system. Malaysia had also sent delegation to the conference to defend and safeguard its national interests. In line with this, Malaysia had proposed and supported three draft articles, which are Article 42 on laws and regulations of states bordering straits relating to transit passage, Article 51 on existing agreements, traditional fishing rights, and existing submarine cables, and also Article 55 on specific legal regime of the exclusive economic zone, and that were the three articles that Malaysia had supported during UNCLOS 3. So that's all for the introduction of UNCLOS 3. I'll now pass to the next presenter.
Thank you, Angeli. Assalamualaikum warahmatullahi wabarakatuh, and a very good day to Dr. Zaki and my fellow friends. My name is Isli Minti Ishaq, matrix number 271831. I will continue our presentation today by explaining about the background of the Third United Nations Conference on the Law of the Sea. First of all, I would like to talk about the conference session and the location. In accordance with the decisions and subsequently either on the recommendation of the conference as approved by the General Assembly or in accordance with decisions of the conference. In total, there are 11 sessions of UNCLOS 3 were held, starting from the 3rd December 1973 until 24th September 1982. It was held on various places such as the United Nations headquarters in New York, Office of the United Nations in Geneva, and more. Secondly, I'll be explaining about the compositions of delegations. According to United Nations Department, the compositions of delegation at the UNCLOS 3 sessions participated by various countries, which can be divided into different categories of continent. Among the Asian countries comprised of Japan, China, India, Indonesia, and also Malaysia. Meanwhile, European countries that participated in UNCLOS 3 were Germany, Russia, United Kingdom, Sweden, and Greece. Other Latin American countries also sent their delegations to participate in the conference, namely Costa Rica, Colombia, and Brazil. African countries also sent their representatives such as Egypt, Nigeria, Tanzania, and South Africa. Let's move to the next sections of the background. There are 6 groupings of states and organizations with shared interests that will be explained. First, Group 77. The Group 77 attempt to establish joint positions, particularly on one issue that gave itself a community approach, namely the seabed outside of national jurisdiction. Secondly, the Archipelagic Group. This group provided a forum for its members to discuss and develop strategies for promoting the archipelagic state and archipelagic regime. Essentially, it prevented the rights of the archipelagic states from eroding. Thirdly, Straits State Group. This group was regarded as clarifying the concept of transit passage regime for strait and distinguishing it from the archipelagic sea lane passage regime for archipelagic waters. Straits State Group will be the focal point for activities to promote safety of navigations and marine environmental protection in the strait. Fourth, landlocked and geographical disadvantage group. A landlocked state is one that lacks of a sea coast. Landlocked states distinguish from other states in one crucial way. They do not have access to or from the sea. Some of these examples of landlocked state participated in UNCLOS 3 is Lesotho, which is a state surrounded by South Africa, Bhutan, which is between China and India, and Mongolia, between China and Russia. Next, the major maritime power, also known as the Group of Five. This group is made up of countries with the most advanced maritime capabilities. which are United States, the Soviet Union, Japan, United Kingdom, and also France. During UNCLOS 3, the Soviet Union served as the group's anchor member. It is a concept of an institution that is operational, capable of generating revenue, imposing international taxation, bringing multinational companies into a structured relationship, responsible for resource planning on a global scale, as well as for the protection and conservation of the marine environment and scientific research. Last but not least, the non-governmental organization. The nature of NGO contributions in marine governance, management, science, and conservation is almost as diverse as the nature of NGOs themselves. NGOs are not a monolithic block, and their mandates, focuses, and tactics differ as a consequences of the feature of their leadership, membership, history, including environmental concern and crisis that spark its foundation, and on occasion their financing sources. My last explanation for today's presentation is about drafting committees. There are 3 committees in total. Committee 1 are dealing with the seabed and ocean floor, as well as the subsoil beyond the boundaries of national jurisdiction. Committee 2 are dealing with general sea law, which includes territorial sea straits, economic zones, continental shelf, high seas, landlocked state access, archipelagos, island regimes, and enclosed or semi-enclosed sea. Lastly, Committee 3 are dealing with the marine environment, marine scientific research, and also technology transfers. That's all from me now. I will pass to Zahin to continue on the package deal approach in negotiation procedures. Thank you.
Thank you, Islin. My name is Muhammad Zahin Ashraf bin Hisham, my metric number 2720 and 20. Next, I will continue to explain about the procedure of adopting proposed draft legal text as a consensus approach during the UNCLOS 3. As you know, during the UNCLOS 3, they used the negotiation based on the consensus as the mechanism to make the final decision. Basically, the consensus is about the original method in the conference to reach a final decision, which means that all the states will give their consent and compromise on the subjective matter in the agreement. So, why they use the negotiation by consensus during the UNCLOS 3? Because to avoid the majority vote from the minorities group, especially from the developing country. For example, consensus already used by the General Assembly regarding on the seabed mining issue. Why General Assembly used this consensus? Because to manage the problem among the states and reach consensus among the largest number of the states with conformity interest. As a conclusion, negotiation by consensus might be the one way to make the right decision, because all the states record their interests and can achieve the quality among them. Next, I will continue to explain about the package deal approach in negotiation procedure during the UNCLOS 3. The package deal is a procedure to be followed at the conference session. It is important because to ensure the effectiveness of the conference meeting, where the work among the communities will progress at the same pace. This is the comprehensive approach that all the main problems are addressed with fair giving between interested parties and interested group. In a short, the package deal will combine all the related issues as the main issue. If a state agree with the package deal, it means that the state must agree with the issue that is stated in the package deal. It ensures the effectiveness of the meeting as all the main problems are addressed. For example, there are some major issues that has been discussed and at the package deal, such as the exclusive economic zone and the continental shelf. Besides, all the interests are categorized and arranged according to its related main issue. As a conclusion, the package deal is about the all issue that were discussed in the package deal.
Thank you. Good day everyone. My name is Romisha Pushpanathan and I'll be explaining about the Malaysia's contribution in the drafting of the legal text of Law of Sea Convention. Malaysia was a strong advocate for the prevention of marine environment pollution, and during the drafting process, non-articulated states such as Malaysia were tasked with clarifying the exact rights of the coastal states used for international navigation under the new regime of transit passage. As the lead coordinator or district states, particularly for the Monaco and Singapore streaks, Malaysia was more directly concerned with the control of navigation and prevention of pollution in the states. At the second session of plenary meetings on UNCLOS 3, the chairman of Malaysia delegation to the conference reiterated that Malaysia was very conscious of the great danger of marine pollution, so little importance seems to be attached to the security and other legitimate interests. Consent of coastal states which should not be expected to bear the cause of damage to the marine environment caused by pollution and accidents. This was due to the condition in the Malacca Straits at the time. As one of the most important international straits in the world, it was experiencing high volume of traffic with an average of 150 vessels passing through each day. There were a lot of ships collision, and because of these, oil research and oil spills were common concerns at the time. Although general cargo vessels account for most of the casualties and the number of tanker casualties, that was of the greatest concern to the littoral states because that possessed the most potential to cause serious pollution damage to the environment. So to protect the marine environment, Malaysia delegates have proposed during the 5th and 6th session for the second committee for the drafting of Article 42, which stated that the laws and the regulation of states bordering states under UNCLOS 3 prevention, reduction and control of pollution by giving effect to applicable international regulation regarding the issues of oily waster and other resources substances in districts. Now I'll pass the session to Anjali.
Thank you, Romisha, for explaining about Article 42. So now I will explain about Article 51, which is about existing agreements, traditional fishing rights, and existing submarine cables. So this article focuses on navigational and fishing access and rights in the archipelagic waters. This article explains that an archipelagic state shall respect existing agreements with other states and recognize traditional fishing rights and other legitimate activities of the immediately adjacent neighboring states in certain areas falling within archipelagic waters, and the terms and conditions for the exercise of such rights and activities, including the nature, the extent, and the areas to which they apply, shall, at the request of any of the states concerned, be regulated by bilateral agreements between them. Such rights shall not be transferred to or shared with third states or their nationals. An archipelagic state shall respect any existing submarine cables laid by other states and passing through its waters without making a landfall. So now, if you look at Malaysia's stance or rationale in supporting this article, it was to ensure that its interest in the archipelagic water is safeguarded or secure. And Malaysia was very much concerned about the claims made by Indonesia on East and West Malaysian waters, which could have adverse effects on Malaysia's fishing area. Before the LOSC 1982 was established, there were four bilateral agreement or treaty between Malaysia and Indonesia, namely Continental Shelf Boundary Agreement in 1969, Malacca Straits Boundary Agreement in 1970, Malaysia, Thailand, Indonesia, Malacca Strait Boundary in 1971, and also Jakarta Treaty 1982. And in the Jakarta Treaty 1982, Malaysia had allowed the Malaysian fishermen to fish by using traditional method in Indonesian archipelagic water, which is in the Anambas Island. So Malaysia had gained the rights of fishing access in the archipelagic waters, and it has been recognized in the LOSC. So that is all about Article 51. I'll now pass to the next presenter. Thank you.
Thank you, Anjali. Now, I will continue to explain about the Malaysia's contribution and rationale in the drafting of the LOSC provision on Article 55, Specific Legal Regime on the Exclusive Economic Zone or EEZ. The motivation behind the Malaysia's support this article is to protect and develop our marine resources in our coast. The EEZ seems provide a lot of advantages to a coastal state, especially in order to safeguard our marine resources, and it was attract Malaysia delegations to support this article, besides preventing any dispute such as overlapping, illegal exploiting, and any maritime dispute. The key provision in UNCLOS 3 on the EEZ is Article 55. It made clear that the EEZ is a regime that is neither under sovereignty of the coastal state nor part of the high sea. Article 55 of LOSC, Specific Legal Regime of the EEZ. The EEZ is an area beyond and adjacent to the territorial sea, subject to specific legal regime established in this part, under which the rights and freedom of other states are governed by the relevant provisions of this convention. It clearly stated that the maritime power which recognized the coastal states, especially developing coastal states, and constitute a majority at the conference with the full respect of this article. They were not going to drawing from claim to has exclusive right to the natural resources in the water in zone by the side of the coast. For instance, we can look at Malaysia-Indonesia dispute of EEZ in the northern region of the Straits of Malacca. All of important resources really beneficial to both countries in terms of political, socio and also economic. As the delineation of EEZ boundary lines is yet to be finalized, the situation has created uncertainty regarding the status of national fishery jurisdiction for these both countries. And regarding to this dispute, drive Malaysia to support this article to protect our sustainability of marine resources and prevent any circumstances dispute in the future. Malaysia is one of the proponents that actively participate in drafting, proposing, negotiating for the specific legal regime of the EEZ. During the 25th conference meeting on 5 August 1974, for the second committee, Malaysia delegates also expressed his delegation's solidarity with others developing countries of Asia, Africa, and Latin America in fully supporting the establishment of an exclusive economic zone beyond the territorial sea up to a limit of 200 nautical miles. According to one of the Malaysian delegates, Casey Vohra, Malaysia delegates supported this article as a necessary measure to protect Malaysia's marine environment in the zone and to prevent the pollution as much as possible, especially ship-based pollution, which has recently created a lot of serious marine problems for our country. And Article 55 really fully benefit from access and the exploitation living and non-living resources of the zone, and also enable the country to develop our emerging fishing industry. That's all from me. Thank you.
Thank you. In conclusion, the third UNCLOS that has produced 2 stations in 9 years from 1973 to 1982 is one of the major compromises in the history of international treaty lawmaking. Malaysia has been an active participant in the Law of the Sea Conference since its independence in 1957. Malaysia has proposed and supported draft article, which is Article 42 on laws and regulations of states bordering state, Article 51 on navigational and fishing access and rights in archipelagic water, and on Article 55 on specific legal regime of the exclusive economic zone relating to transit passage Malaysia, signed on 10 December 1982 and notified on 14 October 1996. With that, we thank you.